More than 200 years ago, Americans fought a revolution against big government.
Orange County, California, Courthouse, 700 Civic Way, 850. State versus Witherspoon.
Right, but I need that little microphone.
Translator for the juror arrives.
We're present, defendant is present. Let the record reflect that, like an entry in the minutes, that the court has requested a court reporter for these proceedings, and the court has advised me that there is not a court reporter available. In order for there to be a court reporter in these proceedings, it would be necessary for the defendant to provide that court reporter and to make an application for costs for the purpose of paying for that court reporter to the court. We do have a monitor who is recording these proceedings.
I'm sorry, when you say she makes an application, you mean ask for a waiver of costs so that they will provide the court reporter?
No, ask for an application for payment of costs. Would you like me to go over that again? The record shall reflect, and the clerk is requested to enter into the minutes the fact that this court has requested a court reporter for the defendant in this case. And I have been advised by the court that they are unable to make available a court reporter. And I'd like the record to reflect that. The defendant is advised that they may provide a court reporter at their own expense, as parties do in civil cases routinely throughout the state, and to make application to the court for payment of those costs, as is often done by indigent defendants, even those represented by private attorneys, for experts and other necessary resources to assist them in defending. What I'm saying essentially is you're going to have to go the normal route that you do with experts and other ancillary resources in criminal cases. That is, include court reporters in that general category.
All right, thank you, Your Honor.
But we would not be able to provide a court reporter for you as we begin with the evidentiary portion of this trial. Now, I would advise the jury is present. I'm prepared to give the three Wagener instructions, the Series 100 instructions. Are there any preliminary matters that counsel would like to raise before we begin?
Well, in speaking about the pretrial instructions, I would request the 100 through 106, which I think was provided by Mr. Thank you. And then Mr. Carroll reminded me about the admonition that you'll be given to the jury not to do any research, because there's a lot about Julie Witherspoon's child custody case on the internet, so I'm concerned about that.
I haven't looked at this, but that's a standard part of the instructions as far as I know. Yes, you're not doing any research on your own or as a group.
Do you mind adding, including going to the internet?
I believe it's in there.
Okay. All right, and then finally, Your Honor, after Mr. Carroll does his opening statement, I would then ask you to consider under penal code, outside the hearing of the jury, I just wanted to let you know what I wanted to do after he presents his opening statement, that I would ask to present an argument for dismissal under penal code section 1113. That the facts charged, he recites the facts, and he simply just doesn't have the interference, which is the first element of the 602.1b offense.
Well, as I've said to you before, the appropriate method to attack this problem is not with a pretrial motion. We need an evidentiary record, and if the evidence in your mind is lacking in any crucial element, your recourse would be to file a motion for acquittal under 1115.
Well, it's actually 1118.5 because it's a jury trial, but
yeah.
Absolutely. But I think you also have authority, and if I could just make the record under Penal Code section 1113.
You can make the record, but I'm advise you what my ruling would be, and asking if you have any grounds for an exception to that ruling. You have a question of fact here. There's no stipulation as to the facts. The people aren't stipulating. You're saying that you have these facts to prove that are undisputed, but you haven't done that yet. And if you do that, and they are undisputed, you might have grounds for an 1118 motion, but not for a motion before any testimony.
Well, my position is that, looking at Penal Code Section 1113, that I would be entitled to ask you to exercise your authority as the judge, and after hearing the opening statement and what Mr. Carroll intends to prove.
It's not evidence.
I think that if you hear the facts, as he claims that he's going to prove, that you're entitled to dismiss it at that early stage, after hearing the opening statement.
Well, you're again betraying your civil background. This is done in civil cases quite regularly. Judgment on the pleadings prior to trial, but I've never seen it done in criminal cases.
Well, maybe the statute is a little used, and it strikes me, because it is separate from the 1118.5 and the 1118, obviously the legislature is given an opportunity to the court to say, wait a minute, you've recited all the facts that you say that you can prove, you haven't even mentioned an interference.
I'm not prepared to do that in a criminal case, and nor do I anticipate or expect that Mr. Carroll will fail to argue interference, and even if he didn't, he's not allowed to argue in his opening statement all the elements of fact that may or may not come in through the witnesses. It's an opening statement. It's not evidence. It's not required to be comprehensive. It's not required to address all the issues in the case. It's not even required that he make an opening statement. I know what you're saying is often the scenario in a civil case where there will be an opening statement by plaintiff's attorney, and an inpatient judge will often say, you don't have any case, dismissed, and take it up on appeal. And frankly, very often those cases do come back.
Right.
And all the judge is doing is buying a little time, right? I've heard some of those cases myself where a judge about to retire has used that as a vehicle to avoid going to trial, and after his retirement, cases come back. I've had to actually do the trial. So I'm very loath to be proactive to the point of doing that in either a criminal or a civil case.
Well, just in closing, I understand what you're saying, so I'm not going to do it because you've indicated what your ruling would be in any event, but I think that this statute, and I didn't have a chance to shepherdize it because I was working on the jury instructions, but I think the statute gives an option to a judge who begins to understand that this was an unethical prosecution to begin with, probably retaliatory, because it doesn't make any sense. And
that's the way you look at the case. I don't have any mindset as to whether that's true or whether some other scenario is true. Totally neutral about what the evidence is going to disclose.
Yeah, I just in closing, because I don't want to keep the jury waiting any longer, but it just seems to me that there has to be a mechanism to protect defendants being held to put on or defend a case that makes no sense.
That mechanism is known as a jury trial. And
no,
the jury is acting as an arbiter of the facts, someone that is a reservoir of community standards that is going to be able to listen to the evidence and perhaps make some subjective value judgments as to who stepped over the line here, as you say, whether it was the officers or whether it was the defendant. This is going to be a decision made by a group of 12 of your client's peers representing community standards, and they will decide, using their judgment and discretion, how the facts should be interpreted. That's what makes this case complicated. This is not something that a single judge should interpose himself into. It's a community issue, an issue of community standards. That's why we have a jury. That's why the jury trial is the resource that we've developed to handle issues of this nature.